Hello everyone, this is the video of Legal Studies, Class 12, Unit 1st, that is Judiciary, and topic is Center-State Relation. Basically, if you remember in my previous video, we have discussed about the concept of judicial review. So this is the extension of that video only, that is Center-State Relation. So we are going to discuss the Center-State Relation under the heading of judicial review only. It's not a separate class. So keep in mind that we are discussing basically judicial review. So here we need to understand how we can apply the concept of judicial review while defining the center-state relation. So let's check it out. Through Schedule 7 and articles from 245 to 263. Keep in mind, Schedule 7 and Article 245 to 263. The Constitution of India describes the various dimensions of the relations between center and states. However, such relations between center and a state can be categorized as legislative relations. This relation talks largely about the legislative kind of relationship between center and a state, which means what are the items subject over which a state can make laws and what are the subject items over which center can or parliament can make the laws. Second one is administrative relations. So talking about what are the administrative powers and how it can be divided between center and the state. The third one is financial relations. So talking about the financial topics. So likewise we have three types of relationship, that is legislative, administrative and financial. But in context of our topic, that is judicial review, I will be discussing only the legislative relations and not the administrative relations and financial relations. That we will discuss later. Okay, so let's begin with the legislative relations. Part 11 and articles from 245 to 255 describe the legislative relations between center and state. Under the provision, that is Article 246, the Parliament can make laws for the whole, again pay attention here, for the whole or any part of the territory of India. Territory of India includes the states, union territories and any other area for the time being included in the territory of India. Whereas the state legislature can make laws for whole or any part of the respective state. So a state government can make laws in that state only. For the example, Telangana government can make laws regarding this state, Telangana state only. It cannot make any law regarding the things that fall in the neighbor state, that is Maharashtra, or in the neighbor other state, that is Karnataka. But Parliament can make laws for rest of the countries. So this is the difference. Besides, the Constitution expressly divides legislative powers between the Union and the states in three lists, as we have discussed already in our 11th class, that is Schedule 7. And the lists are the Union list, the state list and the concurrent list. The Union list consists of 100 items, over which the Union Parliament has exclusive authority to frame the laws. Some of the significant items are foreign affairs, defense, armed forces, communication, posts and telegraph, foreign trade, etc., which are mentioned in the Union list. So on these subjects, Parliament has exclusive power to make laws. A state has no role to play. The second one is a state list. It consists of 61 items, on which ordinarily the state alone can make laws. These include public order, police, administration of justice, prison, local governments, agriculture, etc. So these are the subjects over which a state can make laws on its own. And the third one, that is the concurrent list. It consists of 52 items, including criminal and civil procedure, marriage and divorce, economic and spatial planning, trade unions, electricity, newspapers, books, education, population control, and family planning. So these are the subjects over which Parliament can make laws as well as state governments can make laws. So both have the power to make laws on these subjects. But in case of conflict between the law of the state and union on a subject in the concurrent list, the law of the Parliament prevails. So what it's saying that though even the state government has the power to make laws, the subject mentioned in the concurrent list, but if on the same matter Parliament has made the law, whether prior to the state government or even after the state government, means if a state government has made the law and later Parliament has made the law on that subject, even then it is Parliament that will prevail, not the state. Well, if you remember that we are studying here not the concept of center-state relation, rather the concept of judicial review. So now, where is the role of judicial review in such relationship? Well, before explaining that, I believe you understood at least the legislative relationship between center and the state through the articles 246 that we have discussed and through these three lists, that is union list, state list and concurrent list, that defining the subjects over which these two governments can make the laws. But if there is any dispute regarding any law made over any subject mentioned either in the concurrent list or in the state list or even in the union list, then judiciary through the concept of judicial review resolves that dispute. So this is how the concept of judicial review is related to the center-state relation. So I believe now this concept is very much transparent for you to appreciate what does it mean. So this is all for this video. I believe you must enjoy this video because this is the conceptual part that you need to appreciate in order to understand the concept of judicial review. So see you in next video.